Hello, everyone, and welcome to One Civil Law. For today's story, we turn our attention to Nick Rekieta's wife, Kayla, who has filed her own motion to suppress in relation to the case regarding her and the drugs that were found. So, as you will recall, Nick was accused of, and his wife was accused of, the same offenses. That is to say, possession of the drugs, 26 grams. They are co-tenants. They're married of the same property. So they are both in joint constructive possession. So they can both possess them both at the same time, plus the guns, plus the kids are there with the guns, as we know. So all that stuff. And she has moved to suppress on the basis of sufficiency of the search warrant. Now, as I've said before, I believe the search warrant is essentially unattackable, but maybe there's something here. So let's sort of go through the legal principle that we need to sort of analyze this under as we're sort of trying to analyze this, and so we can understand what we're doing for. Okay, so to get a search warrant, you need to specify what you're looking for and where you're looking for it. And you need to have sufficient indicia that you can find that thing in that place. That's the goal, right? That's the specificity of a search warrant. We don't allow general warrants, which is we're just going to come into your house and look for stuff, right? We don't allow that. That's something the British did. We don't allow that. We need you to come to look for something specific. And then you say where you're going to look for it. Are you going to look for it in the house? Are you going to look for it in the guest house? Are you going to look for it in the garage? Where are you going to find the thing? And then you go search for the thing that you're looking for in that place. All right. So if we want to know if there's sufficiency, the way we would analyze that is by trying to determine whether or not there's enough indicia that the thing we're looking for can be found in this place. This is a search warrant for drugs in the house. So do we have enough information? Do we have enough indicia to say that we're going to find drugs in the house? That's what we're looking for. And again, if we're trying to determine what level of certainty we're looking for, it's a very, very low standard. It's probable cause. It is relatively low. Where exactly that is, different lawyers will disagree. I've said 1 out of 10. If you wanted to say 2 out of 10, I wouldn't quibble with you very much. But, it's something in that ballpark. It's not a lot, as opposed to preponderance, which is 5.1, as opposed to beyond a reasonable doubt, which is like 9.5 to 9.9, right? So we're not looking for very much. We're looking for something like 1, maybe 2 out of 10, not a whole lot. Great. So do we have 10 to 20% certainty based on the information that's available? Okay, so let's read this and see what Kayla has to offer to the picture. Fun times. All right. So to the Honorable Court, the state and their attorney. This matter came before the court for contested omnibus on October the 28th, 2024 at the Candido County Courthouse in Wilmer, Minnesota. Shane Baker, Candido County attorney, appeared for and behalf of the state. Maggie Culliver appeared on behalf of Ms. Rekieta. No testimony was offered. The state offered an application for a search warrant receipt, inventory, and return without objection. Okay, the facts are thus. On May the 22nd of 2024, Detective Quinn Pomplin with the Candido County Sheriff's Office applied for and obtained a warrant to search the defendant, Kayla Rekieta's Candido County in Minnesota home, which she shares with her husband. Did you know that? Did you know that she lives together with her husband? Did you know that? And their 5 children. In addition, the warrant granted the Sheriff's Office the ability to search Nick's person. It certainly did. We've discussed that before. The allegations contained in the search warrant were as follows. And this is her characterization, so we'll see how it goes. An unidentified reporter heard rumors about the Rekieta, presumably Rekietas, from other people in their church. There were concerns about neglect of children, possible controlled substance, and questionable relationship with an additional couple, Aaron and April Imholte, a married couple. Well, she ain't April Imholte anymore. So she has her name changed back. So she ain't April Imholte anymore. The Imholtes may have been staying with the Rekietas. Lol. The home was in disarray and cluttered. The children were hungry, not fed, wearing clothing multiple days in a row, and started smelling. Nicholas appeared lethargic and high or drugged while driving a car around. Nicholas walked randomly out on sermons and was exhibiting behavioral changes. Kayla looked anorexic, and Nick had begun losing weight. Nicholas had injection or track marks on his arm. Okay, relatively fair characterization. The application for a search warrant was silent on whether the unidentified reporter was a person known to law enforcement, which shouldn't really matter very much, but okay. The application for a search warrant was silent on whether the unidentified reporter was a reliable source, which only matters a little bit. People are presumed to be reliable unless there is like indicia to the contrary. So a general report is understood to be reliable. That isn't to say it's sufficient. There's a difference here between sufficiency and reliability. So a report from somebody is generally deemed to be reliable, but it may not be sufficient. Depends on what they're saying, specificity, and other information. Detective Pomplin indicated that he was personally familiar with Aaron Imholte's social media presence. He did say that. The application for a search warrant was silent on the source of the information that Nicholas is a social media blogger. Is anyone denying this? The source of information would be the world for that particular fact, I'm pretty sure. The application for a search warrant was silent on the source of information that Nick is known to drink excessively during his video blogs. Again, you could watch some of his content and potentially come to that conclusion. Detective Pomplin viewed blogs created by Nicholas and Aaron and made the following observations. There was a change in Nicholas's appearance from January 2024 videos to May 2024 videos, including that he appeared to have lost weight, appeared tired, and appeared strung out consistent with controlled substance use. Nicholas' studio is in the basement of his residence. It is. Aaron Imholte indicated that he and his wife were getting a divorce. They did. Aaron Imholte indicated he had experimented with drugs. The videos made it apparent that the Imholtes and Rekieta were friends who recently had a falling out. They had a bit of a falling out. They don't seem to be getting along that well right now. In Aaron Imholte's videos, April Imholte appeared tired, lethargic, and strung out. Nicholas and Aaron Imholte appeared in the same room during videos. On May the 22nd of 2024, Aaron published a video blog insinuating that Nicholas was using controlled substances, that Nick needs to get help and help for his children because of substance, and there was a video where Nicholas had a white powdery substance on his nose. If we get into the issue of the video being watermarked again, I am going to lose my shit. On May the 21st of 2024, Nicholas put a video blog online that showed him drinking what appeared to be an alcoholic beverage, in which he appeared to be under the influence of controlled substance. I've seen the video. I think that's a reasonable characterization. During the video, Nicholas leaves to use the bathroom and returns with a white powdery substance on his nose. I think it's debatable, but, that's a reasonable characterization. I'm not sure that I necessarily would have agreed with that in the naked abstract, but I think that's a reasonable thing to believe that you're observing. The deputies believe that Nicholas was under the influence of a central nervous system stimulant. The deputies believe Nicholas ingested the substance through his nasal cavity off screen. Well, if you believe it to be a powdery substance on his nose, then he ingested it through his nose would be a pretty reasonable conclusion. During the video, Nicholas appeared to struggle to read the screen, rambled, and slurred speech. Yeah. Very much so. There is no indication contained in the application for a search warrant as to what time the day of video is created, whether children were under Nicholas' care, or if there were any other adults in the home caring for the children at the time when the video was created. I don't really know how those have anything to do with anything because he's not being charged with child neglect, or maybe, and I don't think she is either, unless they're going to correct me, because I know there was a debate over what she exactly was being charged with because there was a cross-reference in the charges to a different subsection, and I didn't really know why the cross-reference was there, but it seemed like they were being charged with the same thing, but maybe there was a difference. I know he was being charged merely with the fact that children were present at a place drugs were. In her charges, there was a difference in the sub-charges, or it was a cross-reference, which I didn't know why they put it there, but, fine. Detective Pomplin alleges that Nick had been the victim of swatting, and Kandiyohi County had responded to those calls. Settlement conference is tomorrow. Detective Pomplin misstates his qualifications as a DRE and that he claims to have training experience in making evaluations with individuals with whom he's only viewed in video productions and not personally interacted. I really think that's a mischaracterization, but, fine. The United States and Minnesota constitutions protect against unreasonable searches and seizures. It certainly does. Law enforcement may conduct a search and seizure upon securing a warrant that is supported by probable cause and issued by a neutral detached magistrate. Unlike proof beyond a reasonable doubt or preponderance of evidence, probable cause requires only a probability or substantial chance of criminal activity, not actual showing. And again, what does that mean in terms of percentages? Different lawyers will agree and disagree on that. But probability or substantial chance does not mean more probable. It means a probability. It means a substantial chance. It means more than a trivial chance. It means more than a speculative chance, but not much more. So again, 1 out of 10, 2 out of 10 would be where I would put it on the scale. But I'm sure other lawyers would disagree. I'm trying to reduce linguistic concepts to a numerical score. But, that's what I say, but okay. Plus, it's drugs, which as a practical matter has a tendency of lowering it because drugs. So assuming it was higher in the first place, but drugs though, the war on drugs has not necessarily been kind to the Fourth Amendment. So, curb your enthusiasm, as they say on that one, when it comes to your Fourth Amendment protections a little bit. The task of the issuing judge charged with determining whether probable cause to search exists is to simply make a practical, common sense decision whether, given all the circumstances set forth in the affidavit, including veracity and basis of knowledge of persons supplying hearsay information, hearsay is available in a search warrant. Hearsay is fine, but then you have to question its credibility. So hearsay is not as good as a direct report, but it is permissible. So anyways, given all the circumstances, there's a fair probability that contraband or evidence will be found in a particular place. That's right. So what I've said before is kind of this same idea, right? What you do is you take everything together in combination. Everything together in combination. And so no particular piece of evidence needs to be dispositive. So no particular piece of evidence needs to be the smoking gun. That's certainly not required. And no particular piece of evidence needs to even necessarily be high quality unto itself. You can have a lot of low quality evidence if you have enough of it. So it's basically, do you have enough? Can you add enough numbers together to get to this relatively low threshold? So if your evidence is kind of shit, but you have a lot of it, then maybe that's enough. If you have 1 or 2 high quality pieces of evidence, maybe that's enough. And also things in between. So, all that kind of stuff. So that's sort of what we're reaching for. So that is the correct legal standard. And that's kind of what I've said before. So, yep. Let's see. The affidavit must be sufficiently detailed and include all evidence law enforcement has that supports probable cause to believe the items sought are at the location to be searched, and must describe with particularity the things to be seized. I don't think that's actually quite right. I don't think they do have to be sufficiently detailed, but I don't think it's true that it has to include all evidence law enforcement has that supports it. I don't think that's correct. Now, normally law enforcement probably would want to, because, having more is better than not having more. But the law only requires 2 things here. It requires the police tell the truth, and it requires them to have enough stuff to meet their standard, and it requires them to disclose any information they do have that would tend to show that it's not true. So they have to disclose anything they're aware of that would undermine or mitigate or suggest against their warrant. So they have to include all that stuff. I don't think it's necessarily true that they have to include everything that's favorable to them, though. I don't think they have to. They just have to have enough stuff, and the things they disclose has to be true. So I don't think that's quite right, but okay. Affidavits must not be conclusory. In other words, you can't just say it's true because it's true. You have to actually have reasons and facts and stuff. But should detail the underlying circumstances that support the affiant's belief that there's probable cause. Please tell us the reason that you believe that this is true to the level of certainty that we require. Why do you believe these things, officer? Please tell us. Please tell us enough things so that we believe it too. Recital of some underlying circumstances in an affidavit is essential if the court is to perform its duty and not merely serve as a rubber stamp. The court has to have enough stuff in order to determine this. If the magistrate is to perform his neutral and detached function and not merely serve as a rubber stamp, the magistrate must be provided with more than mere opinion, conclusion, or belief. Actual evidence of some variety would be extremely helpful. Thank you. That would be great. All right, so that basically is a correct statement of the law. Let's move into the analysis as it applies to this situation. The information reported to law enforcement has no indicia of reliability. The information in the affidavit can come from a variety of sources, including eyewitness testimony, informants, or surveillance. However, for the warrant to be valid, the sources must be reliable. If an informant is used, the affidavit must usually demonstrate the informant has previously provided reliable information or other independent sources corroborate. That is typically true, right? It is typically true. So yeah, like, why do we have confidence in this person and what they're telling us? So like, yeah, their reliability in the past would be helpful. If they're bringing other things to the table other than their word would be helpful. Although, incidentally, we might be able to get those things ourselves as the police. They don't necessarily need to bring it to us. We could go get it. So if, some guy says, I think, Tim is a drug dealer, I see him asking sketchy, and I see kind of people coming at all kinds of hours of the day, and, they seem to be doing drug deals. I'm pretty sure he's a drug dealer, right? Is that enough by itself? Probably not. But what might the police do? Well, the police might decide to conduct surveillance. They might conduct a sting. They might interview people. They might ask other neighbors what they've seen. They might try to get video cameras if there are any in the area. Someone's Ring doorbell. Who knows, right? But yes, why do we believe this guy? Or this guy has been a really reliable person in the past. He's come to us 5 times in the past and told us about drug deals. And every time he's come to us before, it's been pretty reliable. So he's probably reliable the 6th time too. That works too. Yes. That makes sense. In our case, the offense is not even bothered to recite the source of much of the information. No mention is made of whether the information was from a reliable or identifiable informant. The report disclosure does not reflect the anonymous reporter's possessed firsthand knowledge. Moreover, the information reported was not corroborated by independent facts or verified through further investigation. Now, that part I disagree. That last sentence is where they lose me. No, I don't think that's true, because there was independent information, namely the video that was posted with the watermark, don't you know? For example, being an independent piece of information. Also a confession, although it's Nick's video, but it's still Nick lives in the house. So we're searching the house and the places where Nick lives, which also happen to be the places that Kayla lives. So she gets dragged along for the ride. So I don't necessarily agree that there was an independent investigation. There was some, but okay. In addition, the reported information is made either more suspect by the fact that Nick, a well-known internet personality, has been a victim of recent swatting activity, likely initiated by Aaron, who had a recent falling out with her Rekieta. I don't know what the truth to that is. Litigation privilege covers the statement, because she can say things. She's covered by litigation privilege, but I have no knowledge about the belief of that, but okay. The facts alleged by the investigating deputy are conclusory and based on pure speculation. I'm not sure about that, but okay. The facts that an internet celebrity may have appeared to lose weight, appeared tired, and appeared strung out are conclusory in nature and not factual. No, I don't really agree. We did a before and after, right? We saw some videos, and then we saw some later videos. So I don't think that's quite conclusory. Likewise, the allegation that April and Holte appeared tired, lethargic, and strung out are mere conclusions that fail to recite facts leading to such conclusions, but he told us a little bit about his expertise, which led him to be able to form the basis of those conclusions. He's a bit of an expert, basically, because he's been trained to recognize these signs. For instance, this is an age of prescription weight loss medication. Nice. Essentially, everyone is losing extraordinary amounts of weight in a short period of time. Okay. However, no independent investigation was done in that regard. Nicholas also suffers from insomnia, yet no independent investigation was done in that regard. Well, they don't necessarily need to, right? They don't necessarily need to look for those things. The investigation goes where it goes, and it comes when it comes. And if they have enough information, they have enough information. That they could have done more and learned more things is not the right issue. They only have to disclose what they know. So, the degree to which the police knew these things is not readily apparent, but okay. Yeah. In addition, the mere fact that Aaron Imholte posted a dubious video blog insinuating that Nick was using controlled substance does not make said blog factually corroborating evidence. It's at best unreliable hearsay. By itself, that's probably true. But that's kind of the problem, as we've discussed before. Yes, you can attack any individual piece of this, but that's sort of the problem, right? We look at it as sort of its combined whole. We don't really look to the individual pieces. So is Aaron's report particularly credible unto itself? I mean, perhaps not especially, but you put it together with other things and it's like it's an indicia that is suggestive, that seems to be adding towards the conclusion. So, there's that. However, it's much more likely retaliatory due to his falling out with Rekieta's. But they mentioned the falling out. The detective mentioned the falling out in the search warrant affidavit. He mentioned that. And so to the degree that would cast aspersions on Aaron, proper aspersions on Aaron, that information was available to the judge, because they told the judge that. They told them they had a falling out. So it's like, Aaron says this. By the way, they've had a falling out. So they told you that his credibility might be slightly suspect. So since the judge knew, I'm not sure it really matters too much. The investigating deputy does not possess any training or experience in determining drug recognition via video production. That's getting kind of narrow. It's slicing it a little thin, but okay. And is thus not qualified to offer a reliable expert opinion. Yeah, if I've been trained to spot it in person and I watch 4 hours of video of you, and I'm like, I've seen this behavior before. I recognize this from in person. I mean, it might not be exactly the same, but yeah. The expert opinion of investigating the DRE deputy must be discounted, as that opinion is based only on observations of the deputy while watching an internet video performance. There exists no independent corroboration of any conclusions alleged by the deputy. There were no garbage pulls, no allegations from any person there were drugs in Rekieta's home. That's a fair point. I mean, the second part is more fair than the first part. It would have been helpful. It certainly would have been helpful if there had been information from somebody that said there was drugs in the home. That would have been a nice touch. Independent who said that. Moreover, as a DRE, the deputy did not perform any testing on the defendant that would confirm his hunch. Like what? Like what kind of testing would that even be? If the court is to follow the deputy's logic, the deputy could just as easily search Al Pacino's office on the set of Scarface. No. Is Al Pacino's office in the set of Scarface real, as opposed to a theatrical performance? No. I mean, I think we all know that Scarface wasn't real, right? Right? Okay. Are we trying to suggest that Nick was doing a theatrical performance? He convinced a lot of us. If this turns out to be, part of his acting reel as drug addict number 3 for some production, just kudos, masterclass acting. It reminds me of that story from one of the actors of The Wire, who told the story of him getting himself his street Oscar. He said that he was in his makeup and clothing for the production, right? And he was out on the streets, just like, in between shots or whatever, getting lunch or whatever, in his, get up. And apparently someone came up to him and said, look, man, looks like you really need a hit, man. So apparently the method was strong that day. And he convinced, although it's Baltimore, so, that could have just been a Tuesday, but he thought it was a compliment. Anyways. Conclusion. The most disturbing part of search warrant was granted in this case is the utter lack of any evidence or allegation, credible or otherwise, that there were illegal substances located in the home, much less where the drugs were located in the home. Well, that part less so. In the home will be sufficient enough. But I mean, this is the right issue. This is better. This is better than what Nick came up with. I don't think it works, but it's better, so I'll give her points. At least it won't be probably laughed completely out of court. Controlled substance use is not illegal in Minnesota. Possession is illegal. Okay. Although it's a little bit hard to use without possessing, but fine. There are no allegations contained in the application for a search warrant that recite any firsthand knowledge of illegal substances being present in the home. That's fair. We do not know the nature of the white powdery substance alleged to be present on Nick Rekieta's nose. The nose knows, though, nor does the deputy. It's just as plausible that it was sheetrock dust as an illegal substance. No. We're arguing that Nick is doing a little light sheetrock work in between camera sets. I need to use the bathroom. Also, I really need to put up some sheetrock right now. That home remodeling isn't going to take care of itself. Quick home remodeling break. I don't know, man. I don't know. We don't know whether Nick was actually consuming alcohol, nor does the deputy. There are some clues. We can't field test the video. I don't know, man. I feel like we might be able to field test this video, but I'm okay. It's all speculation, conclusory statements, and guesses from people who have no firsthand knowledge of the home. There's a difference between them being conclusions and being conclusory, by the way, just for the record, right? Those are not the same thing, right? Conclusions are, I have a whole bunch of information, I reach a conclusion. Conclusory is, it's true because reasons. So, not quite out. Not quite. Nicholas Rekieta is an internet personality, and in the single video, the only credible evidence contained in the application for search warrant. Well, I don't know that I agree with that. It is the most objective, I think, the most objective evidence. It's the least open to subjective interpretation, probably. And it's direct, which is nice. Nick Rekieta was engaged in an internet performance. We're really doing this. Okay. It's a show for likes and hits. The more likes, comments, and hits the performance generates, the more income is generated. He is an actor. We all know we are not to believe what we hear and see on the internet. Wow. I mean, I didn't really think we were really going to go all the way to the end of the page on that one, but you know, slow clap. We really went all the way to the end of the page on that one. We are really going for it's just an act and just a performance. Well, it was really convincing. Really, really convincing. Also, for what it's worth, of course, as I stated before, probable cause to search, whatever it is lower than preponderance, and certainly lower than beyond a reasonable doubt. So while it's hypothetically possible that, and I've said as much, I think I said this in my very first video. Incidentally, I was criticized pretty sharply for saying it, but at the time, but I said it in my very first video, I think, on the subject. It's like, yeah, it could be that he was over, you don't know how much of it is real and how much of it is performative. I think I said like almost words to that exact effect. But we're not trying to determine what's like true ultimately in reality. We're trying to determine whether or not there's probable cause. And could a well-informed officer with training and recognizing drug use look at that video and be like, I think it's drug use, to a high enough certainty for it to be a reliable piece of indicia that in addition to other evidence gets you there? I tend to think so. I tend to think so, but okay. But I do like that we're going for the full bore. He is an actor. Inside the actor's studio when? What is your favorite word? What is your favorite sound? What would you like God to say to you when you die? I'm James Lipton. Given the reasons provided herein and a shocking absence of any corroborated facts, upholding the search warrant in this issued in this matter, derides, nice word choice, the entire notion of the probable cause standard for itself. For this reason, defendant's motion must be granted. Submitted by Maggie Culver, attorney for the defendant. Well, Maggie, I have to say that your effort is much better than what Nick did. Maggie deserves points. She did some good work, and she did it without like insulting anybody or like being derisive or like anything. She just did it by calm, clear application of law, like a competent lawyer might do. So while I ultimately don't believe I agree with you, Maggie, hey, you did your job and you did it well, and I'm impressed. And I have to say that it's better than I expected. It was better than my expectations. Although my expectations were set by Nick's work. So to be fair, my expectations were really, really low, which may not have been fair, but that's where we were. So I have to give this, what probability do I assess of this working? Well, it's more than I'm going to laugh at it, which is what I did with Frank's. It's more than I'm going to laugh at it and then, oh wait, you're serious, I'm going to laugh even harder with the appeal. Where I said the probability is 0. The probability of this being granted, I think, is I don't know, 10, 15%. It's not bad. It's not bad. The warrant could have used a little bit more direct evidence. It could have been a little bit more basis. That some of the evidence was a little tangential and there was a little bit more hearsay than maybe is ideal, and there was a little bit more patchwork than might be ideal. There's certainly lack of real direct evidence. No one who confirms drugs were in the house. So, good work. Good try. So let us read your super chats and see what you guys had to say. Not a banned account says, how long have you hated Nick Rekieta Esquire? I don't hate him. I try to give an accurate assessment as best as I can based on my understanding of the law and the facts, which is what I always endeavor to do. And then when it's stupid or ridiculous, I point it out because it's stupid or ridiculous. And then when I think it's okay, I say that too. So I don't hate him. And personally, I hope that he's able to, with his plea deal conference tomorrow, ideally, it'd be nice if he's able to strike some kind of deal and probably get off with something that, might not be as crippling. But we'll see how it pans out, I guess. Dog Lover for $4.99 says, always enjoyed these live streams. Thank you very much. Germ70 for $2 says it was Powder Donuts. Powder Donuts would have been a better call than the Sheetrock. The Sheetrock was not the best example. Powder Donuts would have been better. Germ70 for $5 says, it's a comedy bit, guys. Nick did his best Robert Downey Jr. impression. His stances are legendary. Nick W. Marie Z gifted 10 gift memberships. Malcolm Combs says, for $5, I applaud Nick for his great method acting talents. He perfectly captures all my local drug addicts. Fair enough. Fair enough. So, Nick Rekieta has his conference tomorrow in which he has to decide whether to accept a plea deal, assuming one is being offered at all, or go to trial. And he might want to go to trial, because if by some miracle this motion is granted, he has a hell of a claim against his own lawyer for malpractice when he's inevitably convicted. So he's got that going for him. So he may plead not guilty because there is some outside chance this is granted for Kayla. Kayla would get dismissed from the cause of action. So Kayla's case goes away. Nick already blew his shot at that. So the case against Nick remains. Nick gets convicted, and then he appeals on the basis of ineffective assistance of counsel. And so then he has, some probability of that potentially working. So the odds of all those things happening are really, really low, but it's better than the conviction. So maybe he goes forward on the basis of a wing and a prayer that this will be granted for Kayla, and then he can appeal his inevitable conviction for ineffective assistance of counsel. And then he can have that fight. And that'll be exciting. It was today? Oh, I'm sorry. Tomorrow was monograph? Then I misunderstood. It was today and he didn't take a plea. Moved settlement conference to December. What do you mean they moved the settlement conference, though? If he didn't take a plea, why did they move the settlement conference? I'm confused about that. So, yeah, like, if the settlement conference was today, then wouldn't the next thing be to schedule the trial? He has a conference date for December 17th. They had in chambers, and there's a new settlement conference in December. Interesting. So maybe they pushed it forward on the basis of this to see how this pans out. Maybe they pushed it forward on the basis of this to see how this pans out, on the expectation that the judge will make a decision on this before that settlement conference, which would influence the settlement conference, I would imagine. No, trial date wouldn't be the 17th, but settlement conference could be. So yeah, they're probably, it seems based on timing that they're waiting to see how this pans out on the basis that if it's successful, that Nick would petition to reopen his issue. He'd petition to reopen, reconsider, and try to get his case dismissed on the basis that it would be thrown out potentially at the Court of Appeals. So, yeah, he didn't take the plea deal as of yet. No, they moved the issue forward. They moved it to the 17th. So no plea acceptance yet. Later, maybe. Look at the comments. I'm looking at the comments as we speak, Martha. I'm literally reading your comments. What do you think I'm doing here? I don't know if there's any information that there's a federal investigation ongoing. I don't know if there's any information about that. Read the comments harder. I'm reading the comments. I don't like to read the comments, generally speaking, when I'm reading, because it breaks up my flow and interrupts me too much. So I tend to read them more at the end these days. It seems to flow better when I can just get out everything I have to say, and then I do Q&A at the end. So Aaron's case is likely to not go forward. The case against Aaron is not likely to go forward. The principal witness is out of state, and based on my understanding, has made no particular indication that he's willing to travel back for the purpose of trial. So I think Aaron's case is, not going to go anywhere. Aaron is going to ask for speedy trial. The state's not going to be able to make it because they are unable to secure their witness, and the case is going to be dismissed. That seems like the most plausible resolution for Aaron. Nick, Aaron already waived speedy. He could invoke it, though. That's not necessarily like a one-time thing, by the way. You can invoke it at a later time. So he could change his mind. And would start the clock whenever he invokes it. Does Aaron's restraining order against Kayla go away with his case being dismissed? I'm unaware of a restraining order, and no. It wouldn't automatically go away. The restraining order would be independent of any criminal case. A restraining order is civil, so it wouldn't automatically disappear. Carrie Morrissey appealed the Baldwin issue. That's so dumb. You can't unring that bell, man. You can't. The jury's gone, man. You can't get them back. You can't unring that bell, dude. What are you doing, Carrie? The no contact might have been a bail requirement. If it's a bail requirement, then it would disappear. And it makes sense. No contact with the potential victim would make sense as a bail condition. So if it's a bail condition and the case is dismissed, then yes, it disappears. Like Nick, she can't control her narcissism. From what little I know of Kayla, I don't want to say that I know her particularly well, but she never really struck me particularly as narcissistic. So, I mean, I don't know. Under Arizona law, according to Andrea Burkhardt, the Baldwin case can be appealed. How? That doesn't make sense. How could it possibly be appealed? The jury's gone. How can we? If Andrea Burkhart said that Carrie Morrissey can appeal, I'd love to hear what Andrea Burkhart said, because that sounds so wrong to me. But Andrea Burkhart is a specialist in this area of law. She knows more than me. Not to say that I haven't ever disagreed with her. I have disagreed with her. But she's a specialist in this area of law, and I respect her. So if she said it, I'd want to hear what she said before I had an opinion based on that. See, that's what you do when you respect somebody, right? You listen to them and you hear them out, and then you say, oh, I agree, or I disagree. So if Andrea Burkhart said that Carrie Morrissey can appeal this, which makes no sense to me, I'd be like, I want to hear this, because I love to hear on the basis of what you're saying, because that doesn't make any sense to me. What am I missing? U.S. v. Scott? From the United States Supreme Court? You think there's a U.S. Supreme Court case on point? Okay, let's take a look. A Rehnquist era decision holds that when the defendant's mid-trial motion disposes the case on procedural grounds, there's no double jeopardy bar. Let's see. Let's see. United States versus Scott, 1978. Respondent indicted for federal drug offenses moved before trial and twice during trial for dismissal of 2 counts of the indictment on the ground that his defense had been prejudiced by pre-indictment delay. At the close of all the evidence, the trial court granted the respondent's motion. Okay. The government sought to appeal the dismissal, which allows the United States to appeal a district court's dismissal of an indictment, except where double jeopardy clause further bars. The Court of Appeals concluded the clause barred further prosecution dismissed, relying on Jenkins. In that case, following the principle underlying double jeopardy, that the government with all its power and resources should not be allowed to make repeated attempts to convict an individual for an alleged offense, held that whether or not dismissal of an indictment after jeopardy had attached amounted to an acquittal on the merits, the government had no right to appeal, because further proceedings of some sort devoted to the resolution of factual issues going to the elements of the offense charge would have been required upon reversal or remand. Held, where the defendant himself seeks to have this trial terminated without any submission to either judge or jury as to his guilt or innocence, an appeal by the government is from a successful effort to do so does not offend double jeopardy. Because it's like inviting your own error if the defendant is the one doing it. Interesting. Where defendant himself seeks to have his trial terminated without submission to either judge or jury as to his guilt or innocence, an appeal by the government from a successful effort to do so does not offend double jeopardy and has not barred. Okay. A successful appeal on judgment of conviction does not bar further prosecution. A judgment of acquittal, whether based on jury verdict and not guilty or by ruling of the court is insufficient, may not be appealed and terminates the prosecution where a second trial will necessitate retrial. Where no final determination of guilt or innocence has been made, a trial judge may declare mistrial on motion of the prosecution or upon their own initiative only if there's manifest necessity for the act or the ends of public justice will otherwise to be defeated. But where a defendant successfully seeks to avoid his trial prior to conclusion by the merits for a mistrial, the double jeopardy is not offended by a second prosecution. Such a motion by a defendant is deemed to be a deliberate election of his court to forego a valid right to have guilt or innocence determined by trial or fact. Interesting. I think this case is distinguishable, at least in part because the trial judge in this case made a basis on the fact that it was a sanction for prosecutorial misconduct. In situations such as an instant one, where a defendant chose to avoid conviction not because of assertion, the government's failed to make out a case against him. Because a legal claim, the government's case against him must fall, even though it might satisfy a trier of fact he was guilty beyond reasonable doubt. Defendant, by deliberately choosing cheek, suffers no cognizable injury. Andrea might be right. Andrea might be right. Hmm. 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 Although it's okay. Okay. Such interest may be involved in two different situations. First, where the trial judge declares a mistrial. Second, in which the trial judge terminates the proceedings favorably to defendant on a basis not related to factual guilt or innocence, which is not what happened. Andrea might be right. Well, I just got schooled. I just got spanked across the internet. Damn. I just got spanked. Well, fuck me. Oregon versus Kennedy? Okay. You think it's more on point? Okay. Let's take a look at that. Oregon v. Kennedy, 1982. During respondent's trial for theft in an Oregon state court, a state's expert witness testified as the value and identity of the property involved. On cross-examination, he acknowledged that he once filed an unrelated criminal complaint against respondent, but explained that no action had been taken on the complaint. On re-examination, the court sustained a series of objections to prosecutors' questions seeking to establish reasons why the witness had filed a complaint. After eliciting from the witness he had never done business with respondent, the prosecutor asked, "Is that because he's a crook?" It's a little bit bold. The trial court then granted a response motion for mistrial. On retrial, the court rejected response contention double jeopardy clause as made applicable to states, barred further prosecution, finding it was not the intention of the prosecutor to cause a mistrial. That's true. So, yes, but that situation's a bit different than this situation. Yeah. Respondent was convicted, but the Oregon Court of Appeals reversed, sustained double jeopardy, barred because prosecutorial misconduct that occasioned the mistrial, even not intended to amount to overreaching. And then here, where defendant in a criminal trial successfully moves for mistrial, he may invoke, which isn't what happened here, by the way, he didn't move for mistrial. He may invoke the bar of double jeopardy in a successful second effort only if the conduct was intended to provoke the meaning. Yeah, so that's true, but that's not quite the situation. I think the other case is more on point. But interesting, very interesting. Andrea's smart. Andrea's smart. Please scroll down. I don't. Please scroll down where bars were bad faith conduct by a judge or prosecutor. Double jeopardy clause bars bad faith conduct by a judge or prosecutor. Okay. That would be more on point. United States versus Dents, 242 at 224. I'll just read the original. I'll just read United States versus Dents. Why do I need to read the case citing it? Why not just read the original? Why read the thing that cites it? Why not just read the original, right? United States versus Dents, 1976. For repeated misconduct by respondent's counsel during opening statement period in respondent's trial, the trial judge expelled Wagner, the lawyer, and asked respondent's co-counsel if he's prepared. Upon advising that co-counsel had not discussed the case with witnesses, the judges came next morning to prepare. That's rough. Upon being advised that he had not discussed, at that time, the new lawyer advised the judge that respondent wanted the old lawyer to try the case. After the judge set forth the alternatives of a delay pending appellate review of the propriety of Wagner's expulsion, continuing of the trial with the new lawyer as respondent's main counsel, or declaring a mistrial to permit respondent to obtain other counsel, they made the motion for mistrial, which the judge granted. Before the second trial, respondent filed a motion on double jeopardy to dismiss the indictment, which the judge denied. Respondent represented himself at the second trial, which resulted in his conviction. The Court of Appeals reversed, holding that the exclusion of the lawyer and the judge's questioning of the other lawyer left respondent with no choice but to request a mistrial. That under the circumstances, respondent could not have said to have voluntarily relinquished the right. Held, the double jeopardy clause does not bar respondent's retrial. Okay. Those court has held that whether there can be a new trial after a mistrial has been declared without defendant's request depends on whether there's been a manifest necessity for mistrial or ends of public justice will otherwise be defeated. Jury's hung. The judge needs to recuse themselves because of personal problems, whatever. Different considerations obtained when the mistrial has been declared at the insistence of the defendant, whose request for mistrial ordinarily removes a bar to reprosecution. That is true, because it's by consent. But this wasn't a mistrial, so it's not quite the same, but okay. This was dismissal, not mistrial. The Court of Appeals erred in holding that manifest necessity should be applied to mistrial, where defendant has no choice but to request a mistrial. The double jeopardy clause bars retrials were bad faith conduct by the prosecutor, threatens harassment of the accused by successful prosecutions or declaration of mistrial so as to afford the prosecution a more favorable opportunity, which isn't exactly what happened here. This isn't exactly that, so I think the other case is probably closer. Here, there's no good contention or record showing the expulsion was in bad faith to go to respondent requesting mistrial, which basically says the same thing as the other case in so many words. So I think the best case is still this Scott case. I think Scott's probably the best one. Yeah, because this is moving to dismiss, right? That's closer, because the other ones are talking about mistrial. And this one is talking about a motion to dismiss. So this is closer. Yeah, this is closer. Yeah, United States versus Scott is your citation. United States versus Scott. The other cases are relevant. They're not irrelevant, but U.S. versus Scott is the closest. Because this is directly dealing with a dismissal by prejudice. In the case of Scott by pre-indictment delay, in the case of Baldwin by, withholding of evidence, but, same basic principle. This is what happens when you have a woman like Andrea, who's a specialist in this area of law and knows things that I don't know. And then she shows me up on a Supreme Court opinion. Andrea's attacking me right where I live, man. She's attacking me right where I live. I'm supposed to be the go-to. I'm supposed to be the GOAT on Supreme Court. And now I'm getting shown up on a Supreme Court opinion. I'm gonna have to hide my face in shame. We now turn to the relationship between double jeopardy and reprosecution of a defendant who successfully attained not a mistrial, but termination, which is to say dismissal. So this is much more on point. Rehnquist writing, U.S. v. Scott, 1978. We now turn to the relationship between double jeopardy and reprosecution of a defendant who successfully obtained not a mistrial, but termination of his trial in favor before determination of factual guilt or innocence. In other words, the case was dismissed. Unlike a typical mistrial, the granting of a motion such as this obviously contemplates that proceedings will terminate then and there in favor of the defendant. The prosecution, if it wishes to reinstate proceedings in face of that ruling, ordinarily must seek reversal of the trial court. In the present case of Scott, the district court's dismissal of the first count indictment was based upon a claim of pre-indictment delay, substitute, discovery violation Brady, and not on the conclusion the government had not provided sufficient evidence to establish guilt of defense. Respondent Scott Baldwin points out quite correctly that he moved to dismiss the indictment on this ground prior to trial, which kind of is true here, and that the district court chose to grant at the time the government could have appealed the ruling. He also quite correctly points out jeopardy had undeniably attached, which is true, the terminate, since a successful government appeal would require further proceedings in the district court leading to factual resolution. However, our growing experience with government appeals convinces us that we must re-examine the rationale. I just got schooled. I got schooled hard. I got schooled by a bunch of piranha fish. Holy shit. So as I was saying, as I was saying at the very beginning, Baldwin, Kerry Morrissey can totally appeal. Yeah, I mean, this is completely not a problem. I mean, it was obviously at the defendant's request that we moved to dismiss, and there was no adjudication of guilt. So as I've been saying since the very beginning, Kerry Morrissey has every right to appeal this case, and it should be interesting to see how it develops. She's going to lose, though. But I will note, for whatever saving value is left in this, that Arizona could at least hypothetically have a different rule that would not allow for this, because it would be providing Baldwin more protection, and the states can always provide more. So the federal government apparently has no problem with this, but at least hypothetically, there could be a decision, or could come to be a decision, in which Arizona would not allow for this, or New Mexico, or wherever he was being charged. It doesn't matter. One of those southwestern states, they're all the same. Anyways, in one of those southwestern states, there could be a case that says, not so much on this. So there's that possibility, I guess. Lord. Yeah. The land of enchantment indeed. Land of enchantment indeed. I'm not sure how any of this is related to Nick, but nice to have in my back pocket for another time. Being humble makes you more lovable. look, I endeavor to get the law right. I want to get the law right. I want to be a good teacher of law. That's what I want to do. I want to be a good teacher. And then I read this and I'm like, oh, okay. Well, professor got that one wrong. Professor got that one wrong. So, oh well. But yeah, you got to be willing to say, oh, that case is pretty on point. That case is pretty on point. I was like, okay, that's a problem. Oh Lord. There's no A sound at the end of Inholt. If that is the biggest extent of my problems today, then I'm doing fine. Yeah. But, when I make a mistake, I like to correct it. And then, of course, it's part of my continuing thing to just learn things by you guys teaching me. So it's like, oh, I probably won't make that mistake again. So if you combine these cases, then like the only way you could not appeal it would be like if you could prove the prosecutor was doing it deliberately to like goad them into it. But why would they do that? Doesn't make any sense. There's no motivation to goad them. It's not like they were trying to buy time, which would be like the only reason you would do it otherwise. So, yeah. In case I didn't mention it earlier at the earlier part of the stream, by the way, the Diobra read-in thing got rescheduled again. So we didn't do that today because Flying Superman defendant got rescheduled for his sentencing hearing. Unclear why, but he did. So maybe we'll pick it up next time. We should get CLE. Maybe we should get CLE. What else can we talk about? I could delete the entire stream and do a do-over, and then I just have it right the entire time, right? There'd be no evidence of any of this. Just hit that delete button real fast. No. Oh, Lord. All right, I guess I'm going to go ahead and sign off for now. And we'll see how things pan out in this case. So Nick has his settlement conference postponed, presumably to see how this pans out. I think I give this a 10-15% chance of success. There's some good points in there. But, the problem is his probable cause standard is so low, and that I think you're going to be hard pressed to get a judge to agree. But, at least it's cogent. At least it didn't make me laugh and say this is insanely dumb. So that was nice. At least it wasn't like zero, like some other motions that we've covered recently. So until later, my friends, I hope you're all well. This will probably be my last stream until, Thanksgiving break is over. So I probably won't see you for a couple days, but, I'll catch you guys next time. Until later, my friends, I've been on Civil Law. Hope you're all well. Remember to keep it uncivil out there. I've been great. I've been uncivil. Talk to you later. Bye-bye.